Well, good afternoon, everybody, and welcome to the Samfiru Tumarkin live employment law show on Facebook, YouTube. I think we might be on Twitter as well. My name is Chen, and I'm an employment lawyer with our firm's Vancouver office. I practice employment law, disability law, but I'll be here for the next half an hour or so answering your questions. Any and all questions to do with employment law. If you're having issues with your boss, if you're coming back from a medical leave and the company's giving you a hard time, if you're dealing with bullying and harassment in the workplace, if you've been offered a new position, or if you've got some questions about employment contracts or severance pay, please feel free to just type in the question in the box in front of you, and I'll be able to see it on my screen here. If anybody has questions to do with their short-term disability, long-term disability, anything to do with going on a medical leave, I'm happy to try to answer those as well. Got our first question here. So Vanessa from Facebook is asking, your employer wants you to complete a training course outside your regular workday. Do you have to be compensated for this, or can you refuse to do it? So good question, Vanessa. So yes, you do have to be compensated for the training course, right? Especially if it's something the company is asking you to do, right? As part of your job, and you have to compensate it at your regular wage rate, right? They can't just pay you less than your hourly wage, for example. If it's a course that you're just kind of doing for your own personal development on your own time, right? The company didn't ask you to do it. Obviously that's a different story. You might not necessarily have to be compensated for that. In most cases, you wouldn't have to be compensated for that. But if it's something, that the company's asking you to do, yes, you have to be compensated. In terms of whether you can refuse to do it, typically no, unless there's something unreasonable about the request, right? If it's a training course that takes you into the overtime hours, right? If you're completing it after your 9 to 5 shift, then they'd have to pay you overtime. So hopefully that answers your question there, Vanessa. We got more questions here. Another one from Raj. You're asking, can a company consider the signing bonus they provide while joining as part of the severance package calculation they provide for termination with cause? So Raj, I think, I don't know if you meant without cause. So in a termination with cause, a company is essentially saying you've done something wrong, so wrong that they can terminate your employment immediately and without paying you any severance, right? So if you stole money from the company, if you defrauded the company, or you've done something on social media to embarrass the company, issues like that's when a company might try to terminate you for cause. Okay. I think your question in terms of the signing bonus, whether it's part of the severance package calculation, I assume it, in a without cause termination, the answer is typically no. The signing bonus is typically a one-time or maybe two-time payment, assuming you complete some conditions of staying with that company for a certain period of time, right? Your severance calculation is based on typically your salary or your wages, right? Your bonuses might be in there, your benefits. A court would look at if you had been provided with working notice of, let's say, 6 months, right, or whatever your severance period may be. What would you have earned during those 6 months, right? And typical issues, I mean, salary is easy, right? 6 month salary is easy. Typical issues that come up are things like, would you have made a bonus, or how much commissions would you have earned? Or what benefits would you have been entitled to during those 6 months, right? The signing bonus I haven't seen come up as part of the severance package calculation. And so, Raj, hopefully, that answers your question. If I've missed something, just and this goes for anybody, just feel free to follow up in the comments, and I'll get to it in the order that I see them. So we got another question here from MP. What is extremely important to have in a employment agreement for a conditional employment offer? So MP, I think that that probably depends on if you're looking at a perspective from an employer or an employee, right? From an employer side, a conditional employment offer, there's certain conditions you want satisfied, right? So maybe a background check. I don't know, for certain provisions, you want a criminal record check. Very rare positions, I should say, where that's allowed. But it depends on what perspective you're looking at it from. If you're an employee, I think all you really care about is start date, wages. If there's a termination clause in the agreement, you want as little conditions as possible, right? And you want it to be more favorable in terms of, the compensation, your hours of work, vacation, all the other stuff. And then to that point, I mean, the conditional employment offers, I assume that if we're looking at it from an employee perspective, you almost want the conditions to be specific and not vague, right? And not let a company have some basis to back out of it. So MP, I have a follow-up question. Can you put stipulations like obtaining a license before the employer offer goes into effect in Ontario? Yes, for sure. That's probably a big one if you're looking at it from the perspective of an employer, right? And MP, it depends on the industry and the specific context, right? Certain stipulations like that, for example, me, right? I'm a lawyer. If I get a job offer, I expect one of the stipulations to be that I have a license to practice law, right? It's perfectly normal. We got another question from Rudy on Facebook. Your employer they haven't been paying you on time. You've been charged late fees and non-sufficient funds fees from your bank as a result. Are they required to compensate you at all for this? That's a good question, Rudy. It's one of those issues where technically, right, it is a breach of your contract, right? If your contract says you're paid bi-weekly and your employer's late and you have to incur fees because of their tardiness or whatever reason they're late, you can technically claim against your employer for that money, right? Now, practically, is an employee going to sue the company for, $50 in these fees, or maybe $100 sometimes? I don't know. I don't see it happening very often, but I mean, theoretically, yes, you could sue for a breach of contract because one of the terms of your employment is that you're paid on time, right? And if you've had to suffer what's legally called damages or these expenses, you can claim for that. There are also provisions in each employment standards legislation. Each province is different, right? So in BC, there's provisions for, you can only delay payment. You have to pay employees once a month at least, right? There's provisions like that in every province. And so that could be a complaint to the Employment Standards Board as well, right? And your employer could be penalized for doing that. The last thing I'll say on this topic is if they're consistently late, right? And obviously how late they are depends. Are they late a day or are they late a few months? You can claim what's called a constructive dismissal, right? If your employer is always 6 months late paying your wages, that could be considered what's called a repudiation of your employment agreement, right? And all that means is the employer, through their actions, right, they're not abiding by your employment contract, and they've breached it in a fundamental manner, a significant way. You can elect to say, I'm not going to accept these breaches and these changes, and you can elect to resign and claim for severance. Obviously, before you do anything like that, talk to an employment lawyer about it to get legal advice in your situation. Because, like I said, if they're just late one time by a day, that's different than if they're late, 50 times a year and each time is like 2 months, right? There's a difference in the degree of what can trigger a constructive dismissal. Raj, so yeah, you meant without cause. Gotcha. Yeah, so I mean, it's with the without cause terminations. Like I said before, the signing bonus is usually um, a one-time payment. The one situation where it might come into play, um, if part of that payment was delayed and they let you go prior to the payment date of this, let's say the second payment. um, it depends on the terms of your contract, but I can see a scenario where you might be able to get that signing bonus, especially, like, for example, let's say if your signing bonus was conditional on you making it to a year of employment, right? Or the second part of your signing bonus. And your contract says, if we terminate you for cause before the end of the year, you don't get the signing bonus, right? Now, if you're terminated without cause, arguably, and you're terminated a day before your signing bonus was due without cause, arguably there's an argument there where the signing bonus could be part of your severance package, right? So it depends on the circumstances, but I will say in general, I don't see that issue come up very often because severance is kind of based on your regular earnings, right, and bonuses and benefits and stuff like that. So MP, yeah, I thought you were asking for an employer perspective. But yes, I mean, you can certainly put that term into the conditional employment offer. Okay, we got more questions here. I got a question from Beatrice. Beatrice from YouTube. You're on sick leave. You took EI sickness benefits. When you spoke to your employer, he said they've considered your leave as a resignation. Isn't this illegal? Um, yeah, Beatrice, good question. It's interesting. I spoke with someone who was in a similar situation where they had told their employer that they had cancer and they had to go through chemo treatment for a few months, and they need to go on leave, right? And the employer basically said back, when you're ready to come back, you can apply for your job, right? And so it's from my perspective, this kind of stuff happens. Well, I see it pretty frequently, but to your question, it is illegal if the reason that they've considered your leave of resignation is because of your sick leave, right? And from what I'm reading in your question, the timing of things, it seems like that's the case. Um, every province has a human rights legislation. In BC, it's the Human Rights Code. Um, and if you're federally regulated, there's a federal human rights code. But anywhere in Canada, you can't treat someone negatively because they have a disability that forces them to go on medical leave, right? And if you do, the employer's likely looking at a complaint under the Human Rights Code. Um, it's the fact that they've said they've considered resignation or your leave of resignation. It's essentially a termination of your employment, right? They're legally obligated to accommodate you to the point of undue hardship, right? So if you're only off work for a few months, that should be something they accommodate you. That should be something that they allow you to do to accommodate your condition, whatever it is. If they fire you because of it, if they demote you, if they decrease your pay, anything like any negative changes to your employment because of your medical leave is it's likely a contravention of the Human Rights Code. And so what you could do is file a complaint with the Human Rights Tribunal. And you could seek things like lost wages. You could seek an order for reinstatement to your employment if you've been fired. There's all sorts of remedies you could seek under the Human Rights Code. Okay, I got another question here from Raj. Any scenarios that common law guidelines are not applicable for the severance package? That is 1 month for each year of service. Anything in offer letter that would prohibit common law. Yeah, Raj, that's a really good question. So, we talk about severance a lot on, at least I talk about severance a lot on this show. I know my colleagues probably talk about it as well. When we say severance, a lot of the times we're talking about common law severance, right? Common law severance is, age, you take into age, length of service, how senior you are, the availability of comparable employment, so what the job market's like, and there's probably 100 other factors for common law severance that courts have considered. What I'm seeing more often, and it's across all provinces, are these contracts that employees sign. And what these contracts will say is essentially, you don't get common law severance, right? You get what the contract says you get. So in BC, the language sounds something like, in the event you're terminated, we will provide you with pay in lieu of notice in accordance with the BC Employment Standards Act, something along those lines, right? And then it might say, you agree you're not entitled to common law severance. What that is saying is that, your age, your position doesn't come into effect. You just get what the contract says. And if the contract says you get a week per year of service, then that's what dictates. So you look for that term in either your offer letter or maybe an employment contract you signed during your employment. Look for that clause, right? Any clause that deals with the termination of your employment by the company. I would say, hundreds, if not thousands of cases have gone to court on the issue of whether that termination clause can actually be enforced against the employee, right? Sometimes the company wins, sometimes the employee wins. And so that itself is an issue as well. Even if you sign the contract or an offer letter that has this termination provision that kind of ousts your common law severance entitlements, there's still a shot you could argue that termination clause is not enforceable against you. And there's a variety of different reasons. I won't get into it on the show, but there's a variety of technical legal reasons that you could get around this termination provision you've signed. So, the short answer, Raj, to your question, yes, there are scenarios that common law is not applicable. And the most common one is if you sign a contract that says you don't get common law, but you get something else, right? And that something else will typically be outlined in the contract. Obviously, common law severance, you don't get severance if you're terminated for cause, right? As I'm sure a lot of you guys know. Okay. Another question here from Trevor from Facebook. You were just let go from your position after 15 years. They offered you 2 weeks per year. Is this a fair offer? You're 62 and you were considering working another few years. Yeah, Trevor, it's hard to say without knowing more about your situation. There's so many factors that determine whether a severance package is fair, right? One of the most important factors I haven't mentioned yet today is how long is it going to take you to find a new job, right? Severance is a buffer, right? It's not just automatically cash payments to the employee. It's supposed to be a buffer between jobs. So if you're let go today and it takes you 3 months to find a new job, and let's assume that new job pays you the exact same as your old job that you were let go from, then your severance package is likely limited to 3 months, right? Now, there's exceptions to that rule, like there is with everything in the law, but that's an important factor to look at. The fact that Trevor, you're 62 and you're near retirement, the law presumes that it's going to be harder for you to find a job, right? So the older you are, the higher severance you should be paid, or the longer your notice period should be. So I mean, if you've been there 15 years, and let's assume your contract doesn't say anything about your severance entitlements, I mean, I'm thinking, I'm looking at a year, right? And they've offered you 30 weeks. Again, it's a negotiation. It depends on the specific circumstances of your case. And a lot of that has to do with how long it takes you to find a new job. But just from my initial, not knowing much else about your situation, 15 years, I mean, 2 weeks per year, you're 62. That's probably short of your severance entitlements, right? You could get, I mean, technically you could get, assuming, you don't find a new job, there's no termination provision in your contract, you could get 12, 14, 16 months, right? And obviously if you're a CEO, and you're not, you're not working at McDonald's, right? No offense to McDonald's. You're going to get a lot higher, right? You're going to get close to 24 months if you're the CEO of a big company. And that's just because, it's harder as a CEO to find another job that's comparable when compared to kind of a fast food worker. Okay. Another question from Raj. Is the employee eligible to demand year-end bonus amount in the severance package calculation if terminated without cause 3 to 4 months before year-end bonus distribution? Yeah, right. So the short answer is it's possible, right? And it actually does happen in a lot of cases. The long answer is that a lot of, well, it depends. The long answer, it depends on the terms of your employment contract. It depends on if you met the criteria for the bonus, obviously. But if let's say you're let go and you're 3 months before the bonus date, right? And you've been with the company 20 years, and there's nothing in writing, nothing in your contract about whether you get the bonus or not if you're let go before the payment date, then yes, you can claim for it, right? Because your severance period carries you over that 3 months, and you would have been paid that bonus had you worked those 3 months, right? The tricky thing about these situations is a lot of companies will have terms in their contract, or maybe it's a bonus policy that you signed or something like that. It'll say, if we let you go before the bonus payment date, right, you don't get the bonus at all. So look out for the terms like that. But they're pretty, from my perspective, I see them quite frequently. The important thing to keep in mind, even if that term is in your contract, right, if it says you don't get your bonus if we let you go before the bonus payment date, there are quite a few cases where employees have challenged provisions like that and succeeded, right, and said that provision was not enforceable against the employee. So if you're owed a $100,000 bonus in 3 months and the company's saying, no, you don't get it because we let you go, seek legal advice, right? And get a copy of the bonus policy, get a copy of your employment contract, bring it to your lawyer. If you're in BC, bring it to me. I'm happy to take a look at it. And they'll be able to tell you whether you can claim for that lost bonus or not. But Raj, short answer, yes, you can claim for that year-end bonus, right? It just depends on a lot of different other things in your specific situation. Okay, got more questions from Ronnie on YouTube. You were considered a dependent contractor for almost 13 years, never given a contract to sign. You're being let go, and they want you to sign an NDA per your termination. Do you have to sign this? So, Ronnie, you never have to sign an NDA, right? It's if the company is offering you something in return, so if they're offering you some severance or just money in general to sign the NDA, that's up to you whether you want to sign it, right? A fairly common term in any settlements in the employment context is a non-disclosure clause, and it's not a all-encompassing non-disclosure clause. It just says you're not going to tell anybody about the fact that we settled with you and the amount of money we paid you, right? That's what the non-disclosure clause typically says. Some of them are wider than others, but to answer your question, I mean, no, you don't have to sign it, unless they're offering something in return, and you're okay with not disclosing whatever they don't want you to disclose. Another question from Raj. So Raj, you're asking, if you get a severance package for 6 months and then you find a job within 2 months, do you lose severance for the remaining 4 months? So good question. If you get cash, right, for your severance package, let's say 6 months pay is $20,000, and there's no clawback clause in your settlement agreement with the company or whatever you sign upon your termination, you should be okay, right? That money's yours to keep. The clawback clause will say something like, if you find a job in the next year, you have to pay us back X amount, right? So most of the times you're fine if you get cash. Sometimes the clawback clause is more common for salary continuance, where they just kind of continue your salary for, let's say, 6 months. If you have a provision in your contract that says you get 6 months no matter what, right? If you're let go, you're also fine in that situation, right? So Raj, it really depends on what the terms of your severance agreement with the company was, right? And look for that clawback clause and whether that's in there. But if there's nothing in there, then you're fine, right? They've paid you out a severance package. It's yours to keep, even if you find a new job. Okay, got a question from Candice. Candice, you're asking, can your boss dictate what you put on your social media accounts or tell you to take posts down? Yeah, Candice, that's a good question. It's kind of a developing area in the law. Your two questions are a bit different. So can they tell you what to put on your private social media account? No, right? If it's a company social media account, that's obviously different, right? If your boss is telling you to post this on the company Twitter, you got to do it, right? If it's your private social media account, typically no, they can't tell you to do something. They can, however, right, tell you to take things down if it causes the company harm. So the distinction is, if they're telling you to take positive action, to do something on your account in terms of, posting a tweet or posting a picture, that's different than if they're saying, hey, you posted this picture or you posted this, you tweeted this, you got to take that down, right? They can ask you to take it down where the content you've posted affects the company's reputation in the community, because you're associated with the company. Situations like that are still kind of a gray area, but the news. I'm sure everyone's seen the news stories where a certain employee tweeted something and they got fired over it, right? And sometimes those terminations are upheld, right? If you're really embarrassing the company during your private time on your private social media, but people are associating that with the company you're with, that's been held to be, a reason to let someone go. So Candice, I mean, the short answer is it's a gray area. They can't ask you to, post things on your social media, but they certainly can sometimes ask you to take posts down if it affects their business in a negative manner. So I think that was all the questions for today, and we're out of time anyways. So I'll be back in a few weeks. My colleague is on tomorrow. If I've missed anything, I don't believe I have. But yeah, thanks everyone for joining. I hope everybody has a great weekend. And I'll be back in 2 or 3 weeks.